So this webinar is intended to provide solutions to employers in response to the FTC's new rule. I'm Ruth Ann Daniels. I am a partner at Gray Reed and the head of our labor and employment law practice. And presenting with me today is my partner, Jay Aldis, who is also at Gray Reed. He's in our Houston office while I'm in the Dallas office primarily. Couple of housekeeping items as we get started. First, there is a chat box, and we'd love for you guys to ask questions either as we go along or as they occur to you. Jay and I'll try to address them as we can. And if we don't address them at the time we see them, we'll try to address questions and deal with some of those questions at the end as well as time allows. The other housekeeping item is that at the end of our presentation, there will be a QR code that will allow you to scan with your phone and to get any kind of CLE credit that you may want to get for attending today. So I hope you'll do that as well. All right, so the way that we're going to go through this today, we're going to start by talking about that new FTC final rule that has caused much angst among employers. And we want to first explain that rule to you. I think it's really important that we understand what the FTC's rule says and means to us so that then we can talk about the workarounds and the ideas that we have for you as employers to deal with that new rule. We are going to, for purposes of this presentation today, presume that new rule is going to be passed, although you'll hear from us later on about the reasons that we think it most likely won't ever go through. Nevertheless, we're going to be prepared. And as lawyers, obviously, we are problem solvers by trade. And so today we're going to consider this rule a problem and talk to you about how we address that problem. All right, so the Federal Trade Commission's non-compete clause rule, referred to as the final rule. Now, the reason we call it the final rule is because they've been messing around and threatening to do this since early January 2023. They put rules out there for comments. They put some things out there, and then they've come up with this final rule that has now, it was issued April 23rd of 2024. It was published in the Federal Register. And once it publishes in the Federal Register, the deadlines begin to run. So it was published on May 7th of 2024. And currently, without more and without any court intervention or stays or anything like that, it's going to take effect for employers on September 4th, 2024. So that's D-Day. We think it will change. But right now, and for purposes of us looking at solutions, we are considering that as of September 4th, 2024, we are going to have this non-compete rule, the final rule of the FTC in effect. So what is this final rule? What does it mean? What is it? How does it affect us? This final rule virtually bans all new non-compete agreements after the effective date of the final rule. Again, for purposes of today, consider the effective date September 4th. It renders unenforceable all existing non-compete agreements with employees who don't meet the criteria for a senior executive, which we'll talk about briefly. And it requires employers to notify effective employees of the final rule before the effective date. I mean, it's not enough for the FTC to tell us we can't enforce our non-competes that we have in place. No, we have to actually notify people, hey, we can't enforce this rule. So, and it kind of adds insult to injury in a lot of ways. So what does the final rule ban? With respect to a worker other than a senior executive, it is an unfair method of competition for a person to enter into or attempt to enter into a non-compete clause, to enforce or attempt to enforce a non-compete clause, or to represent that the worker is subject to a non-compete clause. So, you know, those letters that our clients have us send out to warn the new employer that our former employee is subject to non-compete. Obviously, we won't be sending those out because they aren't going to be subject to the non-compete clause if this rule goes through. Let's talk about one exception. So when we all read the FTC's rule, and by the way, this rule is over 500 pages of rule and advisory comments. So it's pretty meaty, and I'm just pulling out the things that I think are the most practical and reasonable for you to know as an employer. But when we first saw it, we saw this one exception, and I got to tell you, we all just, thought, all right, we will figure this out. We'll figure out how to make everybody, or as many people as we can, fall into the senior executive exception. So here's what it says. Regarding senior executives, it's an unfair method of competition for an employer to enter into or attempt to enter into a non-compete clause with a senior executive, to enforce or attempt to enforce a non-compete clause entered into after the effective date. We're using September 4th today. So you cannot attempt to enforce a non-compete entered into after the effective date. Or you can't represent the senior executive subject to a non-compete clause where the non-compete clause was entered into after the effective date. So we're like, wow, that's great. We'll all focus on getting non-compete clauses in place with our senior workforce before the effective date, before September 4th. We got a lot of work to do. We got to get a bunch of non-competes in place. Well, the FTC is way ahead of us on that. They go into great detail, number one, about what a senior executive is, and number two, how limited you are in getting non-competes in place with senior executives even prior to this effective date. Let's take a look at that a little bit further. So what does it mean? It means an employer may not enter into a new non-compete with a senior executive after the effective date. Okay, we get that. After the effective date, we can't enter into non-competes with anyone. But an employer may enforce a non-compete that's already in place with a senior executive as of the effective date. So who qualifies as a senior executive? An employee who is in a policy-making position and made total compensation of at least $151,164 annualized. Now, we're not sure, or maybe I didn't read deeply enough to determine where they came up with that amount, but that's the amount that the compensation has to be for this senior executive, which I doubt in most cases is going to be hard to meet. So what meets the policy-making position? In other words, they said it's a senior executive, has to make that much money, has to be policy-making. Well, that's where the FTC really kind of squeezes us on this. They say a policymaker to fall under this exception as a senior executive is going to be the business entity's president or their CEO or an equivalent position or any other officer of a business entity with policymaking authority or an individual policymaking authority similar to an officer. My brilliant idea when I first saw this was, wow, we are going to call in a bunch of senior executives and we're going to set up a retreat and we're going to say, hey, let's create some new policies for the company. And they're all going to work together and create these policies. And we're going to say, oh, and by the way, this is all confidential and proprietary, and we're giving you all kinds of information about the company. So we want you to sign these non-competes before you go into this retreat. I thought I was so clever to come up with that idea, and it was very short-lived because here's what they say. The FTC requires the employer to make a showing of policy-making authority for somebody other than the president, the CEO, or their equivalent. Now, they've tried to track language from the SEC in this regard, but they go further into what a policymaking authority really means. So we can't just impose policymaking authority on folks and say, well, therefore your non-compete's going to be valid and enforceable. No, again, policymaking authority is defined under the FTC final rule as final authority to make policy decisions that control significant aspects of a business, and it doesn't include authority limited to just advising or exerting influence concerning policymaking. So again, the FTC's a few steps ahead of me at least, and they're making this a lot more difficult for us to put senior executives into this exception. So this senior executive exception, at least it's an exception, so we're glad about that. But again, to summarize, you already have to have the non-compete in place with that senior executive before the effective date of this new rule. And it can't be just any senior executive. It has to be a very high-ranking president, CEO, or somebody like that who literally is making significant policies that affect the business and has the ability to make them and enforce them. So another aspect of the FTC rule, which I think it's important for all employers to know about, is that if this goes into effect on September 4th, we have to provide notice of non-enforcement of non-competes to our employees. So what it says about this, the employer must provide clear and conspicuous notice to workers subject to a prohibited non-compete. And that's pretty much everybody except those limited senior executives. The communication must be individualized. So what they want us to do is create like a communication, dear Joe, and tell Joe what you're going to tell him about the non-compete. You got to send it to current and former employees who would still be under non-compete restrictions. So even if someone's left your company and their non-compete still running, you have to send notice to them as well. And I would suggest something like, dear Joe, your non-compete restriction in an agreement executed by you on X date will not be and cannot be legally enforced against you. So again, adding insult to injury, we have to give notice of the non-compete. The employer must provide the notice by the effective date. You can provide it by hand delivery, by mailing, by email, and they said you could even provide it by text. A few additional comments about the final rule, and then we'll move on to problem solving. The final rule, and we've been asked about this a lot, it doesn't apply to non-competes that are typically entered into by a person pursuant to a bona fide sale of a business entity. So those non-competes are not affected by this new final rule. It doesn't prohibit an employer from enforcing non-compete restrictions where there's a cause of action, there's already litigation, or the cause of action has already occurred where someone's violated a non-compete in the past. So I know we're in litigation a lot over non-compete or restrictive covenants, and I've had people ask, does this go away? Does our litigation end? Is there anything that changes about the status of that? No. They specifically say, if there's been a violation and there's a cause of action, that is not affected by the final rule. And finally, it doesn't explicitly ban non-disclosure agreements or non-solicitation agreements. So that's what we look at, is what it doesn't ban, and then we advise our clients how to work within those parameters to protect the company's business interests. All right, I'm going to turn to Jay now, who's going to talk to us a little bit about the challenges that are already out there concerning this FTC final rule.
Yes, thank you, Ruth Ann. I did want to introduce to you several pieces of litigation that are challenging the final rule that's been promulgated by the FTC. Apparently, a lot of companies and organizations in the U.S. were very aware when the rule was going to be issued, because the very first lawsuit challenging the rule was filed the very same day the final rule was issued, on April the 23rd of 2024. It was filed in the U.S. District Court for the Northern District of Texas and landed in the court of Judge Ada Brown, who is a Trump appointee to the bench. She is presiding over the first of the cases brought by a company called Ryan LLC. There were subsequent lawsuits filed the following 2 days, April 24th and April 25th, The one on April the 24th was filed in the Eastern District of Texas, and it has been consolidated with the one in Judge Brown's court. So now in the underlying litigation, the Ryan case, I'll refer to it as, there are a whole host of plaintiffs, interveners, and movants, all of whom are seeking to have the FTC rule declared unconstitutional, unenforceable, and seeking to have its implementation stayed. The arguments, and I've read the briefing. By the way, if you're kind of a non-compete nerd like I am, the briefing is really, really well done. The one in particular by the U.S. Chamber of Commerce is 62 pages in length, and it goes through all of the history of non-competes in America, including all the way back to 1811. And it talks about how one of the most significant challenges to the FTC rule is that non-competes are a creature of state law, not federal law. And therefore, the federal agency ought to stay out of the business of state courts and state legislatures and let the states dictate what they believe to be the appropriate level of non-competes permitted in their state. The other challenges are that the rule violates the Administrative Procedure Act. Second argument with respect to the unenforceability is that any such delegation of authority by Congress to the FTC violates the U.S. Constitution. And then finally, there's been arguments that the rule is arbitrary and capricious. As I noted, on April 24th and 25th, the two additional lawsuits were filed in the Eastern Districts of Texas and Pennsylvania. On May 3rd, the Eastern District of Texas stayed that lawsuit, and the U.S. Chamber of Commerce decided to intervene in the Ryan lawsuit. The briefing on the motion to stay the rule in Judge Brown's court and enjoin its implementation, the judge just issued an order recently that all of that briefing must be completed by June the 12th. On June the 13th, Judge Brown is going to issue a decision as to whether she thinks there should be a hearing on the various motions for injunctive relief. And she's going to announce that on the 13th. In her order, she goes on to say that if I do not choose to have hearings on June 17th, then I promise to issue an order one way or the other on these various efforts to stay the rule no later than July 3rd, which of course is an important date because that's essentially 2 months out from what would be the effective date of September the 4th, because our clients, our employers, we all need to know whether we have to issue these decisions, whether we can implement a new agreement for senior executives. And so that would give all of the affected parties essentially 2 months to work their way through that, if indeed Judge Brown were not to enter an injunction stopping the enforceability. The proceedings in the federal court in Pennsylvania are also going forward. I looked at the docket sheet this morning, and in fact, on May 21st, the judge in the Pennsylvania case indicated that they were going to issue an opinion on whether the final rule should be enjoined by July 23rd. So a little later than Judge Brown's indication that she's going to issue an order by July 3rd. The judge in Pennsylvania said they would issue an opinion by July 23rd as to whether we would have an injunction stopping the enforcement of the FTC rule. So Ruth Ann mentioned some problem-solving techniques here. Perhaps the problem is solved, the problem being to the extent we don't believe that there should be non-competes, or we believe there should be non-competes and the FTC rule should not be enforced. The courts may very well take care of that. They've done that in the last few years when there were going to be significant revisions to the Fair Labor Standards Act that never came to fruition. But we certainly are not soothsayers with sufficient accuracy to tell you that our hunch that these will not be enforced will actually become a reality. Ruth Ann, I think you got your mic off.
Got it. Thank you. Presuming that this reality does occur, we want to talk now and move to talking about, what we can do what we can with what still works. We're recommending to our clients that this is a very good time to get a grip on what kind of restrictive covenants we have in our workplaces. Some larger companies and some of our clients have numerous restrictive covenants at different levels for different employees. For example, they typically enter into some non-competes. Hopefully, they're drafted narrowly and appropriately, but they've entered into non-competes with some of their senior most people. They've got to figure out whether those fall into the exception and whether those non-competes are going to be enforceable with those folks as policymakers, under the provisions that we talked about earlier. So you got to conduct a workplace audit so you know what's out there. Sometimes we have non-competes with certain employees. We have non-competes perhaps with too many employees. And instead, we may need to, as a result of that audit, put in a non-solicit or a confidentiality non-disclosure agreement with folks. Look back in the personnel files. We've had cases where people could have sworn, our clients could have sworn, someone signed a confidentiality or a non-disclosure agreement, and yet we look back in the personnel files, there's no such thing there. Oh, they signed an old one. It doesn't have our latest and our greatest. Let's, get our houses in order and figure out if this rule goes through, who is under a non-compete now, who's no longer going to be under one, and make sure we get different agreements in place that we'll talk about to protect our workplace if the non-competes go away. Let's lock up those policymaking executives with non-competes that will survive. We know how to define those policymaking executives under the new rule. And we need to look at, okay, are the people who would be subject to a non-compete under the rule, that limited group of folks, do we even have non-competes with them? And perhaps it's a good time to put a non-compete in place with them before the effective date, because remember, after the effective date, we can't even put in a non-compete with our policy-making executives. So now's the time. Make sure your non-solicit agreements are not overly broad. So, our Texas courts have had a number of rulings that say we're treating non-solicit agreements like non-compete agreements. And why is that? Well, a lot of times our clients, employers in general, get really greedy. And either they put an overly broad non-compete in place. Sometimes they put an overly broad non-solicit agreement in place. And when you do, it's not going to be enforceable. But the FTC currently has not attempted, and they've said, we're not attempting to enforce non-solicit and confidentiality agreements as non-compete agreements unless they have the effect of keeping someone from going to work. We'll talk about that a little bit later on. But in other words, here's how we recommend a non-solicit agreement generally be worded. First of all, reasonableness is the key. If we are attempting to put a non-solicit agreement in place, for example, with the head of sales of the company, or with another salesperson in the company, and these are often most effective, then we want to say you're prohibited from soliciting or performing the same work for a competitor with the client whom you worked for while you were here. The key is limit the non-solicit to customers or clients with whom the employee worked with, had responsibility for, or had confidential information about. We see non-solicit agreements where they say, once you leave here, you can't solicit any customer of the company. Okay, that's not enforceable. It needs to say any customer of the company with whom you worked, had responsibilities for, had confidential information about. And further, it's not that you can't ever speak to those folks or work with them again. You can't work with them to sell competitive products. So if a guy who sells widgets leaves and he goes to sell pipes, and he wants to call on some of the customers he worked with while he was at the former company, that shouldn't be prohibited. You should not solicit people you worked with to sell the same products that you sold them before. That's how narrow the non-solicit agreement should be. And I'd argue that, that basically protects your interests. Again, our employers, our clients are sometimes greedy, and they want it to do more than it should. If we try to make it do more than it should, it won't be enforceable and it will be treated as a non-compete and banned. So keep that in mind. We can write, we as employers, you as employers can write effective non-solicit agreements that protect your interests. You just have to do it in the right way. And finally, this is the time. And again, it's the time to do it, whether or not the FTC final rule goes into effect or not. It's the time to make sure that we shore up our non-solicits and make them valid. Also, that we implement effective confidentiality, non-disclosure agreements and practices. And Jay, you're going to talk more about that next, right? Jay, I think you're on mute now.
I wanted to emphasize, because I don't know that it can be overemphasized, the importance of what Ruth Ann said on her previous slide. Because while this FTC rule has been talked about as the non-compete banning rule, it is potentially much broader than that. In fact, it says, to echo what Ruth Ann said, that if you have a non-solicit, you're calling it a non-solicit, but it essentially prohibits someone from working. And I'll read to you the language from the act. Then that is considered a non-compete. The act even goes so far as to say that you can have confidentiality provisions that essentially are operating as non-competes. And I'll read to you that language. I just think it is vitally important that we go back, do an audit, review not only our non-competes, but our non-solicit provisions to the extent we have them, and our confidential information or non-disclosure agreements, because they could be treading on a territory that would be deemed unfair competition. I mean, prohibiting competition and not be enforceable, even though that could be our bread and butter in actually protecting our information. The language from the rule says that a non-solicitation agreement that functions to prevent a worker from seeking or accepting other work or starting a business after their employment ends is a prohibited non-compete. So to the extent it could be argued that one of our non-solicits that we believe is relatively nondescript and limited in its scope, if it could be argued that it functions to prevent a worker from seeking or accepting other work or starting a business after their employment ends, our non-solicit is going to be unenforceable under the final rule. Similarly, at pages 80 through 81, and by the way, if any of you all are suffering from insomnia any evening, read the 550-page informational packet that is appended to the rule. But at pages 80 through 81, the final rule says that a confidential information agreement, so not a non-compete, not a non-solicit, but a confidential information agreement that prohibits a former employee from disclosing any information that is usable in or relates to the industry in which they work, or keeps them from disclosing any information or knowledge they obtain, including publicly available information, rises to the level of a non-compete. In my mind, that's one of the most dangerous aspects of this FTC rule, because if it does go into effect on September the 4th, and we are not able to pigeonhole senior executives into non-competes prior to that time, you could have a situation where none of your people, depending upon the breadth of your non-solicits and your confidentiality agreements, are restricted in any way from going out and engaging in competitive activity. And that cannot be what the goal of this rule is, yet it could be read in such a broad manner. So Whether your non-solicitation provisions are going to survive or not, your confidentiality provisions will become much more important in this new realm in which we're working, potentially as of September the 4th. I want to encourage you to personalize your confidentiality provision. This cannot be a document that is simply pulled off the shelf. It's not a document you pull off the internet. I have litigated at least 100 of these cases over the years, and I have had some success, and I've had my opposing counsel have some success in just pummeling the corporate representative because they could not justify the terms of the definition of confidential information. It didn't fit their industry. It didn't fit their business. It was well overly broad. You've probably heard, many of you on this call, the old saying that pigs get fat and hogs get slaughtered. Companies get greedy when it comes to these confidentiality provisions, and that is not something that's going to fly going forward. Maximize your chance of enforcing the confidentiality provision. Well, we obviously have various protections of confidential information. We have the common law, how our courts have interpreted confidentiality issues. We have the Texas Uniform Trade Secrets Act, which has been a very valuable tool for many of our clients since its inception because it permits us to get an award of fees. We also have the Federal Defend Trade Secrets Act. What I'm going to emphasize, though, is the importance of being able to justify and support your confidentiality provisions. Because the focus may completely shift to your efforts to protect your confidential information, you need to expect those efforts to be strenuously tested in litigation. Because if that's the only thing, that's the linchpin of your protection of your information, that's your linchpin of restrictions that you have on the employee, maybe even someone who's a senior executive who you didn't get fit in before the rule became effective, or they became a senior executive in your company after September the 4th, 2024. Your corporate representative or others you put on the stand are going to be asked questions to test the legitimacy of your policies and your programs to protect your confidential information. I'm not going to read through all of these because it's not necessary, but I'm going to read through some of them because I have asked these in depositions. There's not a single one of these questions that I have not asked the other side when I am representing the former employee, trying to prove that the former employer did not take adequate steps to protect their information. And I've had these questions similarly asked of my corporate representative when I'm representing the former employer who's trying to chase after the former employee. Do you have a policy that informs employees that they have no reasonable expectation of privacy in company-issued electronic equipment, that the information residing on that equipment belongs to the company and the company maintains the right and will monitor such information? Do you have an acknowledgement form signed by employees indicating they've read and understood that policy? Do you actually enforce the policy? What employee training regarding confidential information do you conduct? Are your systems password protected? If so, how often are those passwords changed? Is a password required for remote access? What access to confidential information do employees have from other computers or electronic devices? What steps do you take to ensure employees are not downloading, printing, etc. information for non-business purposes? If you have information that is confidential and it's stored in desks or file cabinets, are they kept under lock and key? Do you have a clean desk policy that requires employees to clear their workstations at the end of each day? Are your employees informed that they must not provide confidential information to third parties? Do you have an adequate confidential, proprietary, or trade secret information policy? Does the definition of confidential information really fit your business? Could you put someone on the witness stand who could swear to that? If so, how is it distributed to employees, and what do you do to confirm their receipt? Is all of your confidential information physically or electronically stamped confidential? Do you have non-disclosure or similar agreements with customers, vendors, and partners every time you provide them access to confidential information? Are you certain all of your employment agreements related to confidential information have also been signed by the company? You would be amazed, or perhaps you wouldn't, the number of times where we have had a very good, well thought out, well conceived, well-designed confidential information agreement or policy. We roll it out to the employees, they return it, and the company never signed. What do you do if employees don't abide by their confidential requirements? Do you actually have a discipline program? Where can you prove that you've ever disciplined anyone for violating your confidentiality provisions? Do you immediately cut off employee access to company systems when they're being terminated? Do you cut off employee access to company systems when they're being investigated? What do you do to ensure employees return all company issued electronic equipment? What do you do if they fail to do so? Do you have an adequate information destruction policy? Be prepared to have these questions posed if this becomes litigation. And you've got to do your best. I can't say that I've ever had a client that meets every one of these criteria, but you certainly want to meet the vast majority of them, because one of the steps to determine whether you're going to get an injunction, and these cases are largely won and lost at the injunction phase, either at the temporary restraining order or temporary injunction level. One of the most important questions you're going to have to answer is, did you take adequate, reasonable steps to protect your confidential information? Those were of some importance to demonstrate the need for non-competes and non-solicitation agreements in the past. But if non-competes and or non-solicits aren't even part of the program anymore, you're going to have to be able to show that your confidential information agreement is enforceable and that should indeed be enforced by the court by way of injunction, because you've taken the requisite steps to ensure that your information is protected.
And let me make a comment too, Jay, that I think, may go without saying, but if we're worried about employees leaving and soliciting our business or competing with us, I have said for a long time, and I truly believe that if we have a very detailed, specific confidentiality agreement, that can be our hammer to enforce a lot of these wrongs without flying in the face of this new FTC rule. And I've had clients ask before, Jay, and I bet you have too, well, I have a confidentiality policy in the handbook. Okay, you know that our handbooks also say these are not contracts, right? We don't want our handbooks to be contracts. We don't want that to be a bill of rights for employees that they can enforce against us for every detail that's in them. They are just a working policy guideline. So if we're suing for a violation of confidentiality, we can't use that handbook policy as a contract. We think it's best practice to have standalone non-disclosure confidentiality agreements. And again, as Jay points out, the fact that you have the policy in your handbook shows your impetus, shows that it's important and that you're attempting to protect confidential information, but that's not a contract you can sue on. That's why it's best practice to have standalone agreements related to confidential information.
Indeed, Ruthann, and it shows not only the importance you place on protecting that information, but just as a practical matter, and I realize I'm preaching to the choir to many of you attorneys on this call, but you also want to be able to be the prevailing party on your breach of contract claim, which you're not going to be if you're simply seeking enforcement of a policy handbook provision. Because under the Civil Practice and Remedies Code, as the prevailing party on the breach of contract claim, you can get your attorney's fees, which is another tremendous hammer that may be of use in this context. You won't have the benefit of that if you are merely trying to enforce the policy handbook provisions. It's nice to have both, have belt and suspenders to show just how important this topic is to the company. But if you're going to try and get your fees, you're not going to be able to get them. You might be able to get them by way of some other vehicle, but you're not going to get them on the breach of contract claim unless you truly have a contract that has these terms.
All right, so let's move on to discuss some other creative alternatives that we have all brainstormed about. I've read about some of these being effective in light of the FTC's final rule. If non-competes are barred, besides making sure that our non-solicit agreements are narrow and effective, And besides making sure, as Jay has just emphasized, that we have valid, enforceable, and tailored confidentiality agreements, what else can we do? So we're going to talk a minute about post-employment bonuses and the pros and cons of that. We're going to talk about notice requirements that we can impose upon employees prior to them leaving. Garden leave, the old garden leave that we always hear about, and we can consider the pros and cons of utilizing that method. And finally, training repayment agreements. We have a couple of ideas there that we want to throw out for you. All right, so let's talk about post-employment bonuses. Now, I always say, and I've argued with my coworkers for a while, we have the statutory non-compete requirements. But I always say a contract is a contract and money talks. If we agree to pay someone not to compete, the debate that we have all the time is, can we do that? Well, we can contract for whatever two parties are willing to contract to do. However, the FTC is going to look at that and say, well, is that employee being penalized by entering into that agreement? Is that agreement basically functioning to prevent a worker from seeking or accepting work? So that's the definition, right? The broad definition of non-compete that the FTC is using. And so if you consider, though, putting in a post-employment agreement and say it's somebody, and again, these can be customized to somebody that you're really concerned about. You're concerned that someone who has been very valuable to your organization, who has very valuable customer or client relationships, is leaving. What about a post-employment agreement that pays them not to compete for a period of time? Now, your first reaction is going to be, well, wait a minute, you can't do that. That's an unenforceable non-compete agreement. Okay, maybe it is. But if two minds meet and a contract's formed, and this person agrees to take X amount of money, or you continue to pay them out for a period of time, and during that period of time, they agree not to go to work for a competitor or for, say, another company, then why couldn't you try that? I think the only downside in this is that if you're wrong, and say you ask the employee to sit out for 9 months and you agree to pay him $10,000. I mean, again, it's all relative to what the benefit is to the company. And say in the last month they're supposed to sit out, they go, you know what, forget that. I got a great job offer with a competitor. I'm going. The FTC says that in situations where you pay someone not to compete, which they, of course, are telling us they prefer us not to do, but in those situations, are we going to get a clawback? Are we going to be able to get our money back? And it's likely that you might lose your money. You might lose a portion of your money if they begin competing at the end of that period or during the last month of that period. But look what you've done. You've tamped them down for a period of time where you then take advantage of that time frame where they've agreed not to go to work for a competitor, and you go out and try to shore up, secure, introduce new relationships to those customers or clients who you're afraid are going to go somewhere else. So this buys you time. It's not completely foolproof, but I would argue, I'm good at arguing. I would argue, how's that worker penalized? I paid them. I didn't prevent them from seeking or accepting work. They chose to take our money and not to do that. So I certainly would make some strong arguments about how we had a contract, you agreed not to, and if you're going to breach your contract, I'm going to come get damages against you. So that's one way to look at it. Let's talk about notice requirements. So in your offer letter or in your contract of employment, if you have a contract, but even in your offer letter, which, terms are treated in an offer letter like a contract, we require at the front end of the relationship that if an employee is leaving, that they give us like 60 or 90 days notice prior to leaving. Again, We also require in that offer letter or that contract that they participate in the transition of relationships at the time they leave. Now, again, what's the enforceability of this? Well, one of my partners says he believes it's enforceable as a contractual term. That if the employee doesn't give you the notice they agreed to give you, and you're going to pay them during that notice period, and you're going to either pare down what they do or let them continue to work, however you want to deal with it. But if you have that notice, once again, you have a jump on the opportunity to continue or to develop relationships that employee had with your clients or your customers that you're afraid may leave with him or her. Now, most of the notice provisions I've seen in agreements say, look, you've agreed to give us notice, both sides have agreed to give notice, whatever, but during that notice period, the employer could decide that we don't want you to work for us, but we still have to pay you out the notice period. Again, you're trying to, trap them for some period of time so that you can get a leg up on what your concerns may be about protecting your business. Another alternative, the old garden leave. The picture's lovely. This implies you're just going to go sit and relax in the garden or the beach or just take some time out. And importantly, the FTC's acknowledged this is not a non-compete. And again, I think the reason that they think it's not a non-compete is because we're paying for it, which I'm not sure how that's much different than this post-employment obligation I talked about a minute ago, except that in a garden leave, and garden leaves they're primarily something we associate with the financial industry. I think they began in the UK, Europe used to use them. They come now and are more popular in the United States. But the whole aspect of a garden leave is, somebody is required to sit on the sidelines for some period of time. It's usually 60, 90 days, but they're still employed. You're just taking them out of service. So you're saying, you no longer have access, but you're still an employee. They get the same compensation and benefits. You're basically paying for the non-compete period of time because they can't go to work for a competitor, because they can't go to work for anybody while they collect and sit out during the garden leave period. Again, gives the employer the opportunity to transition customer relationships. And then finally, we talked internally about the whole training repayment agreement. I consider this more of a retention tactic, but in exchange for valuable training, and this happens a lot in companies where you send somebody off to a conference or a seminar or a week-long class or whatever that you can put real value on, cost assigned to it. In exchange for that, the employee must stay for a period of time. If the employee leaves earlier, they must repay the cost of training. So they would enter into an agreement in which they acknowledge you're paying them, that the cost of the training is X and that they're not going to leave until clearly the employer has had the ability to recapture its investment. And those agreements say, if you leave earlier than that 1 year period or whatever, you've got to repay us, this amount. That's all agreed to. Well, what about exchanging non-competition for some period of time in lieu of repayment? Again, that's something that we have looked into and think that again, arguably, they get a contractual benefit, we get a benefit, and it's exchange of those costs. So I think at this point, Jay, we'll probably move to some questions.
I saw one from David, and if I'm understanding it correctly, he's asking, how does this affect the sale of a business? And my understanding is the rule does not prohibit restrictive covenants involving the sale of a business, because you have to get the benefit of your bargain. You can't buy a company and pay good money for that and then have them go across the street and start competing against you. So my understanding is the FTC rule does not prohibit those as unenforceable non-competes. You still have to get the benefit of your bargain in a purchase. And so if you have a stake in the sale of a business and you receive significant benefit from that, I think you could still be held to the terms of a non-compete. And of course, those are typically much more readily greeted by courts because our judges understand that, even judges who don't necessarily like the concept of non-competes, they understand that they're necessary in that context. And that's why Texas law has said that you can have even a period of 5 years of a non-compete when it comes to the sale of a business. So I don't believe, David, that a non-compete would be prohibited by the FTC rule in that context.
So we did have a question, by a client several months ago who owned, and I don't know if this is a more finessed question, but the person owned a small interest in a business that was being sold, say 5% interest. And if I recall, there is some amount of interest you have to own in order for, a non-compete in the sale of, what if you had the sale of a business and you had, 20 different interest holders, some of them very minimal. I guess the question becomes, could you enforce a non-compete as to all of those interest holders? What do you think about that, Jay?
Well, for instance, Oklahoma has a very high threshold. You have to be a significant owner of that business to be bound by a non-compete, even a non-solicit for that matter. Arguably, that's an old Fifth Circuit case that happened to be mine for good or bad. That was my case that arose out of Oklahoma about 8 or 10 years ago. So, if I'm understanding the question correctly that David was posing, you might not, particularly with this. Many states, even in the absence of the FTC rule, have very much limited the scope of non-compete. So I think you probably have to be an interest holder of some significance.
Another question that we see that's been posed is, whether this post-employment agreement I was talking about, whether that would work if it's embedded in severance. And again, that goes back to the debate I have with my coworkers quite often. We have people who are leaving the company. We want to enter into a severance agreement with them. We want to get a release. We want to pay them a couple of months' salary. And, if the parties willingly enter into that severance agreement and there's a portion of it that says, and you won't go to work for a competitor, and let's assume that we're even smart enough to say you won't go to work for the competitor for the 3 months that we're paying you severance, I would try it. It's not, we know that non-compete agreements put in place at the end of employment are never effective because you haven't exchanged the consideration required, the confidential information required to enforce them. But I have clients all the time that want us to throw in a non-compete provision in a severance, and we may not call it that. We just say, you agree that you're not going to work for a competitor. We don't just say non-compete covenant. We try to soften that. But again, if they, in my opinion, if they agree to it contractually, they take your money and then they stay out of work because that's what their agreement says. That's fine. Everybody wins. If they go to a lawyer and the lawyer says, whoa, that's not an enforceable non-compete because it was entered into at the end of your employment. The question for the employer becomes, are you going to get that money back, or did you pay that money for a release as well, and have you lost your investment? So yes, you can put it in there. Is it foolproof? Might you have to just let that money go because they're signing a release for that money as well? That's the issue, whether you basically lose it. But what does it hurt to put it in there? You might get in trouble with the FTC. I don't know. What do you think, Jay?
Well, the irony could be, because we don't know what this FTC rule does with respect to Texas case law, because Texas, as Ruth Ann said, Texas case law is very clear. You can't roll out a non-compete in conjunction with a severance agreement. That happens a lot. Clients say, oh my gosh, Joe Smith, he's one of our most valuable salesmen. We now realize he doesn't have a non-compete. We need to fold one into his separation agreement. You haven't been able to do that under Texas law. But if this FTC rule wipes out all that law, going back to Ruth Ann's point, if we're not penalizing them, in fact, they're looking into work and they can go work at the end of whatever period of severance we pay. We'd have to pay something else if we were trying to obtain a release as well. The irony would be you might be able to bind somebody to a non-compete by way of a severance agreement that you never could before under Texas law. If indeed if all of that case law is wiped out by this FTC rule, and we're right that doesn't constitute a penalty and you just pay them to sit out of the game, maybe you actually can obtain that sort of relief.
I also saw a question. I'm going to go ahead and put up the slide too for any of you guys who want to hop off, but I'm going to put up the slide so that you can obtain your CLE and get the heck off this call if you want to. But another question that was raised is, how does garden leave really work if the employee doesn't accept the money and doesn't want to go on the garden leave? And I would argue that let's make the garden leave a contractual obligation of the employee at the beginning of the employment relationship or while things are fine at the relationship. Let's make that a contractual agreement, much like the notice provision. If they don't give you the notice that they've contractually agreed to give you, or they don't take the garden leave that you've already agreed to pay them for, I think then that they've breached a contract with you. So I think you enforce it as a contract. Please let me pay you for 3 months while you sit out. No, I don't want to. I want to go to work for this competitor who's made me this great offer. Well, you agreed to sit out and accept these payments, and you will do that. If you go to work for the competitor, I'm going to come up with some kind of breach of contract claim against you, and show how I'm damaged by not having that 3-month period that I was counting on to get, those accounts in order. I think that's the way that I would treat someone that just said, well, I'm not going to go on garden leave. You don't have to pay me. No, you are going to go on your garden leave. That's the way I deal with it. All right. I think we're about at the end here. Might even give you a couple of minutes back, but you see
We actually, sorry to interrupt. We had one person raise their hand, Brenda. So I'm going to go ahead and unmute you, Brenda, so you can ask your question. All right.
we don't hear Brenda.
Okay, how
Brenda,
about
you
now?
can. Oh,
Hi. Hi. I had a question regarding our company's deferred compensation programs. As you know, Ruth Ann, you've reviewed the non-compete aspect of those awards in the past. Do you feel this FTC ruling has changed that because it is a financial penalty for competing, but not a prohibition against it? What's your view on that now, given your review of this law?
I saw some comments in the FTC report, Brenda, in which equity interests that are also attached to non-competes may still be able to be enforced. And particularly in your situation, it's a financial benefit in exchange for not competing, which they can choose to accept or not, right?
Yes, even though it's not equity-based, it's just deferred compensation.
Right, not equity-based, deferred compensation. They can choose to accept the deferred compensation and not compete, or just say, I don't want the deferred comp and go compete. I do not believe that we have been told by the FTC that those are going to be prohibited. And I do not treat those as a traditional non-compete.
Great,
Brenda,
thanks.
Brenda,
Yes.
one thing I'll follow up, and I don't know whether this will be helpful or not, but there are 3 pages in the FTC non-compete clause rule. They're found at pages 246 through 248, and they talk about severance benefits that are being provided in exchange for a non-compete. And so though you might review those, they may end up helping you answer that question as well.
All right, thank you.
Brenda, I'll pop those into you after we get off the call. I'll scan them into you so you can have them easily.
Great, thank you.
Okay. Well, thanks everybody for listening in, and hopefully this was helpful today. Jay and I enjoyed presenting to you, and Hope you'll call upon us if we can ever be of assistance to you. We have a team here in Dallas and Houston that are available to help with any issues that may arise. Thank
Yes,
you.
we really appreciate the opportunity to visit with you. Thank you so much for attending.